So, my name's Blake Farmer. If you don't know me, I'm the president of the local chapter, the Society of Professional Journalists from Middle Tennessee. A lot of board members in here, so thanks for coming out. I'm not great with introductions. Would you all introduce yourselves and we'll launch into this?
Absolutely, I'd love to. First of all, thank you so much. So I've told several of you that I have known in my past and new friends as well. I actually used to have an office right down the hallway, and so it's like coming home to me because I spent a whole lot of time over here and at events at the First Amendment Center, and I was just thinking about, I guess the last time that I actually was standing in this hallway was for John Siegenthaler's memorial. And so for those of you all who did not know Mr. Siegenthaler, I'm telling you, you missed one of the most magnificent human beings I've ever known in my whole life. He helped me and championed me from the time I was a new young law clerk over at Vanderbilt Law School. And so quickly, I'll just give you my quick history for those of you all who are new and I haven't met yet. At Vanderbilt Law School, I was fortunate enough to meet and get to know Governor Alexander. I became his law clerk, went on his legal staff, and then went on his senior staff, worked on campaigns, came back to the administration, worked through that administration. Then I was fortunate again to be called and invited to work on Governor Sundquist's staff. I did a lot of mental health. We were going through the first throes of TennCare at that point in time, and so worked a lot on policy issues. Then went to be both a director and chairman at the TRA, the Tennessee Regulatory Authority, which is everything from energy and electricity to telecom. Now very much a different place than it was formerly, and at that time was fortunate enough to be appointed by President Bush to the FCC, and went to Washington for several years, and then was again fortunate that my career took me to the international level, where many of you all, I hope, have read what I've written, mostly in the Tennessean, about protecting children online and the impact of media. So very au courant that we are right here in the First Amendment Center, and just happy to be here. And now, of course, have had an incredible opportunity to work for the Tennessee Supreme Court and all of the court system across the state at the AOC. And I'll give you some factoids about the AOC, because some of you all may not even know what the Administrative Office of the Courts is, and we want you to know. Have an absolutely incredible communications director in Michele, and I want you all to know that both of us want to be accessible and helpful in any way that we can. With that said, Michele.
Debbie Tate, I'm sorry, I could have at least told them your name. And Michele, in radio, we look at a last name like Michelle's, and we just hope we don't have to say it on the air. Wojciechowski.
Close enough, yeah.
No, help us get it exactly right. So
Wojciechowski.
Wojciechowski, excuse me. But yeah, tell us a little bit about
Okay,
yourself.
so Michele Wojciechowski. And I will say that one of my first jobs in journalism was, you better look up, like I worked at the radio station,
really?
WGHN, the Rhythm of the Lakeshore. I used to do the school news report every morning. I'd wake up. It was probably not that early, but for a high school student, it seemed like an ungodly hour. And I would actually record over the phone to the local radio station the school happenings in our little school district in western Michigan. So I started out as a journalist. I have a journalism degree from Northwestern and spent about 20 years working in newspapers, both on the journalism side and on the management side. And then decided I was going to go to law school. And I did, and was very, very fortunate 2.5 years ago to get this job with the Administrative Office of the Courts, serving as the spokesperson for the Supreme Court and the statewide court system. So Debbie has been with us since January, and we are so fortunate to have her. She's been a great force for the judges and for some of the information that we're going to talk about today. She's been very energetic and has lots of great plans for us. And so we really appreciate the opportunity to talk to you about the proposed changes today. I think that this is great to have a dialogue about it, and so that we can all see where everyone's coming from and work toward getting a rule enacted eventually that is going to be best for everyone. So,
super. Well, I don't know if anyone will take us up on this, but if there were other, because there are some people who were not going to be here today but would follow along if you want to hashtag tweets from this, which is apropos, court tweets. Hashtag court tweets. You know, you don't have to. Tony G wants to do it, you know. All right, so most of us in here are not broadcast journalists. A couple are TV folks, but so we don't run into Rule 30 all that often in the first place. So remind us, for those who don't run into it much, what Rule 30 is supposed to be at the moment.
Okay.
Go ahead.
Okay.
You're the expert.
So currently, Rule 30, which was last amended, I believe, in 1999. Yes, December 6, 1999. Governs media coverage, but media coverage is defined as cameras and recording devices in the courtroom. So there's nothing in Rule 30 that limits anybody from walking into a courtroom and covering it, with the exception, of course, of those cases that may be closed, usually juvenile cases and things like that. So basically what it's doing is it's looking at the equipment. What type of equipment, what you can do with it, where it can be, whether it can have lights on it, whether it can have noise on it. Photographic equipment, still cameras, television cameras, and also there is a provision for radio recording devices as well. The rule right now allows you to have some kind of handheld, it actually I think says cassette tape recorder, in order to use it, like if you want to make sure that you've got quotes, not for broadcast use, but for a journalist's personal use, that is in there. The rule presumes that coverage within the limits of the rule, i.e. a certain number of cameras where they can be placed and that sort of thing, presumes that that coverage is going to be granted. And if there's some reason why there's a challenge to that coverage, the court has to hold a hearing. And those provisions in the rule are going to stay.
And also remind us, for those of us who don't cover courts on a day-to-day basis, what courts fall under you all? I mean, you're obviously not the federal courts, but does this go all the way down to
court? Yes. So it starts with the Supreme Court, appellate courts, Court of Appeals, Court of Criminal Appeals, trial courts, which would include circuit courts, criminal courts, chancery courts, general sessions courts, municipal courts. Also, all courts other than the appellate courts have local rules. So there will be general sessions, local rules for Davidson County general sessions. Sometimes the local rules may cover all the courts in a judicial district or an area. But there are local rules that sometimes either adopt Rule 30 or adopt it with some additional provisions on it. But in most cases, the Rule 30 is going to cover all. Yes.
And can I give a little historical perspective? In 1981, and I don't have the name of the case, I just remember the date, the Supreme Court said that the states could indeed promulgate rules about media access. And so to me, Tennessee has been one of those really on the more permissive and on the cutting edge in terms of opening the courtrooms. I mean, if anybody here frequents federal court, that's just, not the way it is. The day that I was getting sworn in before the United States Supreme Court, of course, I'd hoped that, like, my husband was going to take pictures of me and, we were going to send them to all of our friends. I was so excited about this. And not only was I almost strip searched going in, but we had to put everything, every single device we had in a locker before we could even go in. I was being sworn in before the U.S. Supreme Court. So it's a very, very restrictive system.
So the thinking for updating the rules, can you all sort of go through what that is?
Absolutely. I'm sorry.
No.
Can you all hear Debbie okay?
I'm jumping in when I want to.
Okay.
So the rule does not have any provisions whatsoever for electronic devices, cell phones, tablets, anything like that. And the court wanted to make sure that there was provisions in there for those devices. Right now, there are judges, and I've seen it happen, that will not allow laptops, cell phones, tablets, and things like that in their courtroom. And so the proposed change addresses those devices, presumes that those devices would be allowed for journalists. It does have the provision, which I think has been probably one of the biggest sticking points based on what I've seen, is that the provision follows along with Rule 30 right now, in that you have to seek permission ahead of time in order to bring those devices and use them in the courtroom.
So, and what's that process look like? I mean, I thought that it was 48 hours or something.
Well, it does say 2 days ahead of time, but I can tell you that in my experience, I've never had an instance where that 2 days hasn't been waived. To the point where there was when the Supreme Court heard oral arguments on the West versus Schofield case, there was a television camera that showed up literally minutes. I think it was less than 10 minutes before the oral argument started, and the court allowed them in with their cameras. So
one of the other things that I think is interesting is kind of to look at, you know, what other states are doing, and many of you all can do this. And actually, I pulled up this guide to other states. I sent it to you this morning, which you all might want to look at. And Kathleen Kelly at the Wiley Bryan law firm in D.C. actually did it. She's a good friend of mine, so I can assure you that it was done very well. Alabama requires that all parties have to provide written consent in every civil or criminal proceeding. I mean, so that's a pretty high, you know, barrier. We don't have anything like that in our rules. Alaska does as well. If you cross the line, you can have a 1-year suspension from being able to even be in the courtroom. I looked at California just to see, since usually they are very liberal, and they actually have only one still camera and only one video in the courtroom. So again, we are, you know, much more permissive.
So the way I read the update to the rules, though, I mean, this would govern tweeting from the courtroom, even sending text messages and emails from the courtroom, correct?
The rule would regulate the devices, so whether or not you could have a device. So, for example, and I think some of you may have been in Judge Watkins' courtroom prior to the start of the Vanderbilt trial. There was a hearing, and he wasn't allowing any devices in there. Couldn't have a cell phone, couldn't have a tablet, couldn't have a... was anybody... And I think it was you that said, Tony, that said, I don't know, I can't take notes if I don't have my laptop, or something like that.
I don't know. I'm not sure which hearing we're talking about.
Okay, but there was once where he said no devices at all, and as it progressed, he allowed more devices. But my understanding is that he did not allow cell phones in there. Is that correct?
It's not.
It's not correct. His impression to me was that he doesn't allow any cell phones in his courtroom. So that potentially could happen where, you know, they don't allow cell phones for everybody. This is giving the media and the journalists the right to have them in there if they just say, I'm going to be in there with this. It presumes that will be allowed, and that once they are allowed to have those devices in there, they can then use them to tweet, text, whatever they want.
Have you all talked about how you would enforce this? I mean, would people have to dump their electronics at the door, kind of thing, if they haven't gotten permission?
Well, like I said, there are currently some courts now where the judges don't allow cell phones. Judge Watkins has,
and that's within
told
their
me
right?
that because for anybody coming into the court, not just journalists, can't bring their cell phones in. He said people can't silence them; they disturb the proceedings, and so this is allowing the journalists to say, "Hey, I'm going to be there with my cell phone. I realize I need to be very cautious about that." So it is up to the judge. Oftentimes they assign their court officer to check with people and make sure if they see somebody with a cell phone, they will approach them and say, you know, you can't have that in here, or you can't have that on in here. But if it's a media person who says, I have permission to do this, then they will be allowed.
Right, well, I want to open it up to questions here in a second. Let me ask this first, then we'll open it up. I mean, what is the thinking? I thought that the thinking behind Rule 30 was kind of broadcast cameras, putting microphones places as sort of a distraction. I mean, I thought it was a distraction issue more than you know, sort of an access or, you know, stuff. Is this about distractions, or is it about limiting information escaping the courtroom?
I think you have to look at this in, I guess, and I'm not speaking for the judges or the justices, but I think you have to look at it in terms of the larger picture. You know, so yes, always a judge has been in charge of the decorum and keeping calm and order in the courtroom. So I think that's one whole set of issues. I mean, we can't turn a courtroom into a rock concert, right? And that's kind of what, you know, our culture is becoming. The other one is the larger issue of, you know, the freedoms that we have, the First Amendment freedoms that we have are broad and are the underpinnings of our democracy. But they also aren't unrestricted. I mean, there are restrictions. And so whether it is the right to a fair trial, whether it's the right to a speedy trial, whether it is protecting a victim, whether it is, again, going back to the juvenile example. I mean, so there are balancing tests that go on, whether it's about the physical obnoxiousness and, ability to keep control of your courtroom, or whether it's these larger balancing tests.
Questions? Steve?
So, if a rule arises in response to a need for can you sort of talk about what the need for changes to the rule would be to include these things? Whether it's loss of decorum in the courtroom or what it would be?
Well, Michele said, correctly, there's been a rule. This is really updating the rule. And so it's not like this is a reaction to anything, it's just merely updating the rules. Yesterday, they discussed 3 other rules that are going to be updated. The Supreme Court is constantly updating, rules for the court. We have to, every year, publish many decisions that are made either by the Supreme Court by rule or decisions by a particular trial that then get put into jury instructions, for instance. So, this is just kind of usual and ordinary.
I think if you look at the rule and see that it says that media may use handheld cassette tape recorders, things like that in there, clearly that it's outdated and isn't addressing the technology that's available. When, in 1999, people didn't have cell phones that they could hold up and take a photo or take video of what is going on in the courtroom, and the rule was designed to help regulate that going on in the courtroom so that you didn't have, like Debbie said, you didn't have 6 people out there, the victim is on the stand holding up a cell phone taking a photo or video of someone, and I think that goes to the decorum. Even when these proposed changes were being contemplated and before they were published, I don't think that many of us, myself included, I try to keep up on it, Meerkat and Periscope exploded shortly after these proposed changes were published. So now anyone with a cell phone and an app can live stream what's happening anywhere, including in a courtroom. So they just want to make sure that those things are addressed.
So as kind of as a quick follow-up to that, if there are issues which are coming up with recording, and there was already recording for non-publishable reasons, like for instance, we could have a recorder in there in order to make sure we got quotes accurately. Wouldn't it seem to be a more reasonable thing to extend that logic in order to make whatever was gathered in there not publishable, as opposed publishable directly, as opposed to banning a device or banning a practice in general?
Live streaming versus post-trial.
Right. Would it make more sense to say that you can't publish from the courtroom, or that you cannot stream from the courtroom, rather than to say not take a device in?
So my response is that's exactly why we're here. We want you all to file comments and to give real-world examples. In this example, how would this be dealt with? So I think that's a great example.
But one thing to also keep in mind is the rule isn't banning any devices. It's merely asking that journalists get permission in order to have those devices in there. And in order to use your word, ban them or not allow them, the court has to have a hearing. And people can make their case for why they should or should not be allowed to do that. One of the problems with using a term such as streaming, first of all, if we had made this proposed change a couple years ago, streaming probably wasn't something that the vast majority of people would have even envisioned. And I think we see it again. I'm going to use the cassette tape recorder example. So if you target a specific technology, and then that technology is superseded by something else, then all of a sudden your rule is out of date again, and it's like, well, this is this new technology. Does the rule allow it? Does it not allow it? And that sort of thing. So that's something to think about.
Deborah had a question.
Yeah, I'm just, a lot of times tweeting and things like that with your device is done silently, so there's really no distraction to the courtroom. And I know that distraction, decorum, and those kinds of things are within a judge's responsibility. How is tweeting a distraction, or how does it create a decorum problem if it's done silently?
I'll give you the example that just kind of comes to my mind. I'm not speaking for the judges again. You tweet something and it is kind of so inflammatory that 10 people in the courtroom gasp and start talking. And did you see this? I'm just giving what I could see happening. I don't know how many of you all, have had the opportunity, and this might be interesting too, to sit behind a bench in a very emotional, stressful situation where you are trying to accord the jurors all the opportunity to hear all the evidence, ensure that the attorney's motions are being ruled on promptly, swiftly, and correctly. The victim, if there is one, is being protected. The family of the victim is sitting right behind them. I mean, it is it's a very difficult job. I'm beginning to have more and more and more respect for what these people do all day, every day.
But jurors already can bring their cell phones, though. I mean, they don't have access to the internet, I would assume. I'm just...
Oh, jurors.
No, I'm not talking about jurors. I'm just talking about the whole courtroom. So, bedlam erupts because of something that someone...
And I don't think the proposed change means to imply that texting or tweeting is distracting. Again, it's presumed that that's going to be allowed. It is, you can bring 2 devices into the courtroom under Rule 30. That's presumed.
Sheila?
Can you walk me through some of this, what this actually means? Okay, let's say I'm covering a hearing or want to cover a hearing. Mm-hmm. So that means that I need 2 days to get permission from the judge to bring what into that courtroom? A laptop, a cell phone, a recording device? Is that what I have to get for?
A personal recording device is I believe, let me make sure I'm right about this, is allowed.
I think it says, you don't have to get permission.
You don't have to get
for
permission if you're just using it for quotes and things like that. But if you want to have, so if you just got like a little handheld recorder, but if you want to have, and it defines other electronic devices in here, it's on page 3, starting at line 41, so you can see all the different devices. But if you want to have one of those other devices in there, yes, you need to seek prior permission from them.
So in order for me to just have a cell phone period in there, I have to have permission?
Well, I think you could say in order to have a cell phone, you need permission, but how I view this rule is that it is permitting journalists to have them there, whereas the judge right now could say, I'm not allowing anybody to have cell phones in here.
But I've never seen that happen, and I covered the Vanderbilt rape trial with Watkins. I had my cell phone out, all the time, and it wasn't distracting. There weren't people tweeting. There wasn't bedlam that was erupting, although there were some issues, that happened in the trial. It was a very emotional trial, but, I mean, I've never had a judge tell me, you can't bring your cell phone in here.
And it has happened, and judges are within their right to do this. So really what this is trying to do is protect the right to have those devices in there.
What about a laptop?
Falls under electronic devices.
So in other words, whether it's going to be used, I don't have to say this is going to be used for transmission or not going to be used for transmission. As long as I want to bring those devices into that courtroom, I have to have that permission. Is that correct?
What does permission do? I mean, you're talking about presumed that the devices would be allowed. If that's the case, then if it's the rare instance that they would be blocked, what does permission do? Just that the judge could be prepared to, I mean, what does it do?
So they know, yes, it gives the judge the information.
And knows who's out there and what they're doing.
So if you've got, and let me use an example, and I know some of you have been covering the Holly Bobo case. It's still in the very preliminary stages, but my guess is that when that case gets going, there's going to be probably national interest in people in media wanting to be there. So, and not that you always want to take worst case scenario, But you have to consider that you're going to have people that may not, and I respect all of you and the work you do, and I know that you're very, everyone that I've worked with, and the stories that I've had from judges are all that the media is very respectful of the courtroom and the proceedings and everything like that. Unfortunately, not everybody is. And so, you know, you want to take a case like that has just, you know, torn a community apart just to see what's happened there, and then bring in, and I'm not going to mention any outlets, but you know, you can imagine what some of them are that may do things that just are not appropriate. There was an example that I saw yesterday from the I'm not going to remember his name, but the football player who's on trial, Hernandez, is it? Hernandez. There was a television camera person who followed the jurors on their bus to where they met their cars while the trial is still going on. And you know, he said he didn't take any pictures, but you know, someone at the television station had told him that it would be a good idea to know where the jurors were and that sort of thing. So, and that's really outside the scope of this rule, really would be anyway. But I think it just, you know, there's always the chance there, and again, we don't always want to work to worst case scenario, but make sure that there's some safeguards in place.
Travis had a question.
Well, so if the problem is, or potential problem is, people, journalists, doing things like that, or you were mentioning maybe, you know, unscrupulous outlets, not to mention any names, coming into the Hala Bobo case. I don't understand how I mean, they would presumably also get permission, it would presumably be granted. So, I mean, it seems like just a formality. If it's all going to be granted, I don't understand what it's doing.
Well, there is a pooling section. So
How would that work in regards to tweets and laptops, though? I mean, pool-wise.
Most of the pooling refers specifically to the still cameras and larger cameras. The devices, the Rule 30, when it was originally put into place, would regulate the use of television cameras and still cameras, because those were the only things at that point, pretty much, that were able to capture images. And now a phone can capture image. So really what it's doing is it's extending the rule to those things that are capable of capturing images, which include laptops and tablets and cell phones and things like that. And you know, with apps, that capturing images is taken to, you know, a whole nother level. And it's again, it's allowing the media to have these devices where if you had a courtroom full of people and everybody put up their phone, that would be a distraction. If you've got a courtroom full of people and you've got just a few media people doing it, then it's who are very careful about what they're doing.
There were hands work over here, Chris.
So, going back to your Hollywood example, that judge out there, McGinley, doesn't allow phones whatsoever. I mean, you can't have a thing in that courtroom. So with this now, if this goes into effect, would this now force him to say, if we submit permission, or ask for permission, he would have to allow us to?
He would have to have a hearing if he was going to deny that coverage, and he would have to have reasons on why that coverage would not be allowed via phone. Yes.
And can you explain what the hearing, because I've just never been a part of, what does that hearing on media coverage look like? I mean, it's like you would submit a request under Rule 30 and then they would say no and then you ask for a hearing, or
no,
is it on you?
I think that the hearing automatically
before denying, limiting, suspending, or terminating media coverage, the presiding judge shall hold an evidentiary hearing.
And are media folks like a party to that? Do they make their case, or is that who's arguing?
The burden on the proof shall be on the party seeking limits on media coverage. So if someone is saying that they don't want coverage, then they're going to have to then.
And could this be a turn? Is this just the judge thing, or could the defense not want it?
The defense,
really?
Absolutely, yes.
Okay.
So about that though, so if the judge limits whatever, cell phones, cameras, or whatever else out of a courtroom, and the media appeals, who are they appealing to? Are they appealing to that judge, or are they appealing to another judge?
To that judge.
So the judge that just said no can say no again?
But there would have to be findings of fact and conclusions of law, I think. I'm trying to read the order right now. And the substantial evidence required to support his or her order. And then, of course, there's a section E on appellate review.
And how much time would the media be given from when he says no and when we object to when that hearing is? Because you can see trials are going to be delayed, or we're not going to have time to get Rob or another attorney in there to argue on our behalf. Has that timeline been discussed?
So right now, Rule 10?
Well, that would be for appeal, if they wanted to appeal the judge's decision. There aren't any provisions in here for that, although it does say that before they can deny that, they have to have the hearing. So how I read it, and I'm sure there's much smarter people in here that can probably read it better than I, but how I read it is that if the judge is going to deny it, they're going to say, well, we're going to have a hearing. And normally, the rule really protects the media. The rule is designed more that if there's someone who has an objection to it, not so much the judge. And I think with the rule saying that that it's presumed that they're allowed to have it, and there's also some case law. There was denial of coverage of jury selection in a case in Memphis, and so there's case law on it as well that says no, you need to allow them. I don't know that was necessarily devices. That was more just coverage.
But the rule doesn't really say that you're presumed to allow to have it. It asks that you ask permission. So, for example, unlike Arizona's rule, and they went through a 2-year process to study electronic devices and usage in their courtroom. You don't have to seek permission to bring in an electronic device, but there is still an ability for a judge who sees that a device is distracting or, interrupting the conduct of justice to be able to then take action and remove it. Is that something that was considered by the Supreme Court instead of asking for permission to, say, cover with your, submit text and things instead of that, but rather dealing with the problem if it arose?
I can't say exactly what they considered, but I think that's a suggestion certainly worth their consideration.
The other thing, I think that for you to point out some of what other states have done, I thought that when I looked at it, Arizona had the same 2-day requirement that we did, and that they only allow one still, which doesn't go to your point about tweeting and things like that on your device,
right.
One still and one TV. So our rule is broader than theirs in some ways, but it might be nice to give some examples of other states.
Ask your question.
Yeah, a lot of times for court proceedings, TV reporters are asked to sit in an overflow room, and that's where, you'll have one pool camera in the courtroom, and in an offshore room where we're away from the public, we are logging tape, we are tweeting, we are taking notes. Would that rule apply there? Because that's where a lot of our work is already done, and we're not distracting people there. So we would be allowed to tweet without requesting. Okay.
You're not in the courtroom.
Okay.
And I guess you would already, is this the kind of thing where essentially if this is a trial that's going to get a lot of media coverage, it just becomes someone makes a request and it's open, or does each individual outlet have to make that request? Is that, I don't know how it works currently, really.
Currently, each outlet is making the request, but there's nothing to say that they couldn't make it jointly.
Well, and that's a good question, because a lot of times with sort of declining resources in newsrooms and the inability to put somebody in a court all the time, news organizations are rushing to cover things in kind of as they're needed to cover. The 2-day rule seems like it could be a real burden for people coming in who haven't covered a trial, who are coming in to cover, say, closing arguments, and then to come in there at the end, a judge can just as easily say, no, you didn't ask within 2 days.
Never known the 2-day not to be waived, but
but
that brings up a good point that maybe 2 days is not the appropriate time frame, especially with email and things like that. Where in 1999 it was probably was email as well, but
maybe not. Yeah.
Maybe not. Some of the courthouses probably didn't have internet, so
And may not still.
it may not still.
Chris?
What is I guess this is kind of on the same tier. What does implementation look like? So right now, when we want to bring our camera in, we submit, we have to fax in a form saying we want to come. students who are going to be there who want to have their phones, or is there going to be a separate form that we have to submit solely for electronic devices that we put our names on? I mean, how does that work?
There isn't a form at this point, and when I say form, I don't mean a physical form, but just a form for the request. I think that's something, and actually I've often thought about having a form available for people to use, so that would be something, and I think that would be a great thing to recommend what a form like that may look like. So at this point, the comment period's open until May 12th, and then sometimes that comment period, the court will extend. I don't necessarily anticipate that happening this time because we have had quite a bit of time with it, but and then they consider it, and at that point, it could be weeks, months, sometimes longer. Sometimes they don't decide to make any change at all.
I highly encourage you all, if you have brother or sister organizations like who could send you a form, submit it. And the other thing is, back to, Michele made this point earlier, you know, the judges may still have certain local rules. So it might even be that a judge would really appreciate your saying, you know, here's a form you all might want to consider using.
There's also, I'm aware of some courtrooms and local journalists that have preset agreements, and they're not formal, but there's a couple television stations that I can think of in the Knoxville area that have agreements. They know they can be in the courtroom and they know where they need to be, and it's just kind of a given. Judges are also permitted to file decorum orders, and so they can say, or make it part of the local rules, where they could say, pursuant to Rule 30, we're granting this type of permission to, you know, journalists and things like that. So they can do that if they want.
Looked like there were a few more questions. Yeah, Maria?
Is there getting to the previous question, my concern is the more specific it gets to the journalist rather than the news organization, the more challenging it's going to be for us. Because I can have somebody call in sick at 8 in the morning and I can send somebody else at 9. Or if the trial goes on for 3 weeks, you know, Steve may be sending 2 or 3 people and you may be sending 2 or 3 people to sub in and out. So, you know, I would rather keep it to the news organization rather than specific journalists, and that's what's worrying me is we might have 3 people covering one trial on any given day.
Is this contemplating it being an individual?
No.
So it's for the news organization.
That's certainly something that we can get clarified.
Because if I put in a form saying they're going in with cameras and cell phones, I'm not going to list individual reporters with their cell phones. I don't think judiciary has any right to know that.
I don't think that was contemplated at all, that it had to be a specific journalist. I really don't think it was.
But
and if it's not clear in here, then that would be something
that's something that we'll take back.
Okay.
Sheila?
Do we have to have additional permission, once we get the permission to bring in the cell phone and laptop, would we have to have an additional permission to tweet, text, file stories? Or would we have to just have the
Initial.
So it's kind of a blanket?
But I could walk in there and say, hey, I have a digital recorder. I'm just going to use this for myself. I don't need to get permission. What about with the laptop? If I just say, hey, I'm actually just taking notes on my laptop to help me cover the trial, would I need to get permission for that?
I believe the laptop is covered under an electronic device.
It is right now, but again, I mean, this is really why we're here today, both to hear your comments about this rule. I mean, there's a lot in it, and the more really specific examples that you all can provide and comments, I mean, you know, we are asking you all to provide that.
And I think it's safe to say that the court does not want to limit coverage. They want the coverage in the court. They're not trying to limit it. They're just trying to make sure that there are safeguards in place that need to be.
I've got another question, if you don't mind. Okay, so once I submit the, request, and let's just say we've got a defense attorney who doesn't want his client, wants his client out of the media, or, a particular case. So when I submit the request, the defense attorney objects, and then we're on the spot.
Well, not necessarily right on the spot, but yes, before the trial. I think the rule reads before the trial begins, and that the burden is then on that defense attorney.
And thinking about that, like, and just going back to, say, updating a blog from the courtroom, or, you know, even sending a little story from the courtroom during a long trial when there's not a break, you know, that kind of thing, or tweeting. How would a judge, what findings of fact would a judge make on whether that would be distracting or be a problem in the courtroom if there was no sound issue, if there was no visible sound issue? Would it be just that getting information out in real time is somehow harmful to the trial? Or because the news media has changed, news consumption has changed so dramatically, really, and I think it's everybody's dealt with it. But what kind of findings of fact, you know, almost qualitative about the coverage that is immediate, that would take place before the coverage even occurred? I'm trying to understand how that would look and how they would decide that. That live coverage is somehow bad or distracting.
I don't know.
Your thought on what kind of factors would have a judge say, no, I don't want that?
I mean, I can't comment because it's so hypothetical. That,
right.
And the other thing that I keep going back to is most all of you all have been out there, have relationships with judges already. Neither one of us think that this is going to cause any of these problems. You know, we think, Michele has said, and I'm sure as I get to know you all and see you in the courtrooms more, that, you know, that I will see the respectfulness with which you treat everyone in the courtroom and the decorum that you show. I don't see this as going to be a barrier, a problem. I don't think there are going to be these hearings. I mean, there could be a few. And certainly there could be defense attorneys who see this as an opportunity.
But right now, if a judge denies the permission to have a device in the courtroom, you're out of luck. The rule doesn't allow for a hearing for that right now. Under the rule, well, under the proposed change, you would be granted a hearing for that.
Yeah.
You're talking about live coverage. Live coverage is going on now. So I think the point with whether you're in the courtroom or in the pool room where the video or audio is being disseminated is probably the issue. I mean, live is going on now, and that's not the issue.
So I think you should all just ask for a separate RAM for every trial. Problem solved, right? Keep the media out of the work.
So
you have your own RAM.
this does seem well. I mean, it seems like something that you know, when there's the Holly Bobo trial, it would be, you know, it seems like it would work really well, I guess. But it seems like the one-off you hear, oh, there's a hearing this morning on that. I didn't realize it. That's where I think, oh, I can't go in and take a device of any kind. I mean, that's the kind of thing that seems trickier.
I don't think it's that complicated.
Okay.
Debbie, go ahead.
Well, Michele has been here a lot longer. She's never really heard of a judge yet who hasn't waived the time.
I think if you're in the courtroom and you said to the court officer, hey, can I tweet from this? They're going to go to the judge and say, it's fine. I mean,
but then why have the 2-day requirement at all? Why not just have a permission requirement?
and maybe and I think someone brought that up. Is 2 days appropriate? So maybe it's not. I think maybe that would be a good suggestion.
Some states have 1 day. Many states do have 2 days. I don't know whether it's because when the original rule was adopted, it was 2 days.
You know, the rule could say perhaps
weigh in.
prior to the start of a trial or hearing, and that may be a great way to address that concern.
I think a lot of that may have to do with the pre-planning associated with if there's any wiring microphones, camera placement. That takes planning. You can't, and if you show up with a camera and you want to be in there 10 minutes prior, probably not going to happen.
And I have run into that where, you know, you've allowed one and then a couple others show up and it's like, okay, well, we don't have time to set up another one you can pool, and then there's issues with my equipment doesn't talk well with their equipment or something like that. So
but that's not your problem.
And it's not, and the court has nothing to say other than you guys are going to have to pool, and then they wash their hands of it. Everyone else needs to figure out the pooling, which I know is your problem. But yeah, that may very well be related to that. But again, in the 16 years since the last time the rule was changed, or in the nearly 20 years since the rule was enacted initially, a lot has changed. And so I think that my thought is that, you know, the changes were put in with maybe there wasn't a lot of contemplation about the 2-day time period, and I think that would be a well-founded suggestion to change that.
Some final questions? Yep.
So this obviously applies to media. Under these rules, we would request for permission, but what is stopping people in the public, spectators who just want to come to the hearing, from bringing their phones, from tweeting? Because I know during the Vandy trial, there were just spectators. There are people who are interested, and I know you made the argument that, you don't want any inflammatory tweets being sent out, but why would we have to be regulated and other people not be regulated?
Very good question. A+. You know, I mean,
Well,
this is a new world to me, so I'm kind of like you all. I'm kind of wrestling with some of the balancing as well. Michele can...
Yeah, so if normally a judge is going to, and like I said, I spoke to or emailed Judge Watkins this week, and he was under the impression that there weren't cell phones in the courtroom during Vanderbilt. So, so I'm not sure if that's it. So yes, monitoring it is clearly difficult. So what the rule is allowing is the media to have these devices, assuming that others might not be allowed to have those devices. So, and maybe that needs to be clarified a little bit, but it's up to the judge and the court officers to make sure that's being monitored. And quite frankly, if I was a journalist in there and saw someone tweeting, and I'd point it out.
But couldn't you solve that by flipping the onus and saying that if the judge wants to prohibit certain devices, they have to proactively act?
You could do that, yes.
All right, Rob?
The history on this, it goes back decades. The court started allowing cameras in the 70s at least. And then I think it was 94, 95 when the wording was enacted. The first test of that was the Confederate flag case up in Springfield. The judge threw the cameras out, the Court of Criminal Appeals reversed it. And that was kind of the first layout of how the hearings are supposed to work and how an expedited hearing would work. Then there was a later case in Clarksville where the judge basically ordered us to build a duct line at the back of the which was fine. I had to build duct lines in Tennessee, so that wasn't a good problem. But to follow up on Alana's question, treating different people differently is an equal protection problem. She gets an A+ for her law school studies, and it's a real problem, I think, to say that the DA or a court officer could tweet out or could email out guilty on 15 counts, and a reporter could not. In the Watkins case with Vanderbilt, the court officer ordered a reporter to put to do no tweets from inside the courtroom. So the tweets took place outside the courtroom. Watkins has entered a closure order and threw reporters out without any kind of hearing before. And there are all kinds of bumps in the road. But when we have fair administrative justice and equal justice issues, that's different from the decorum issue, which was the original reason Rule 30 was passed. It only applies to cameras. And this is a broadening. I sense y'all's interest is more transparency and trying to make things easier. And I appreciate y'all's public statements on that very much. There are limitations here that I think we need to get our hands around that are going to cause problems in the Lobo case or in other infamous cases that are going to be coming up in Tennessee in the next 5-10 years. I'd like to see Rule 30 work for another 10-15 years without more issues. But there's some great comments going on in here on how it's going to be applied.
Well, and I think that this is precisely what you all need to do. Give us exact examples of what you're talking about. The unfairness, if it's unfair, of treating different classes of people differently. I mean, that's exactly what the court needs comments about.
All right, well, I think this means we need to make some comments by May 12th. So let's make sure to do that. We might even clap for you all for coming. We appreciate it. All right. Well, thanks everybody for coming, and eat all the, take some donuts back, because Andrea brought them for you, you know. So, no, thank you for what you do. And I think everybody here probably is a member if you're a journalist, but SPJ, come join us.